Hey everybody, how's it going? Hope you're having a lovely day. So today I want to follow up in a video that I did 2 months ago on a company called Cami Research. This company thought that I owed them $100,000 for publishing their own words. They wanted to sue me and I responded, and within 1 day of my response, the law firm that was representing this company fired them. And one of the things I said in that video is that I'm not just trying to get them to leave me alone, I'm trying to change the culture on YouTube a little bit and demonstrate that people should stop taking their review videos down the moment that a company yells and says, I'm going to sue you because you said something bad about me. Because usually the way this works is somebody puts up a review of a product on YouTube that is honest and factual. After putting up that honest review, the company will then threaten to sue the YouTuber, and they'll go, I'm sorry, I'm going to take down the video for 6 to 18 months until my audience commits to supporting me, by which time people will forget that I ever said anything about your product. Please don't hurt me. And when that happens, it sends a message that false and bullshit legal threats will actually work. So what I said in this video is that if you do not take your video down when a company says they're going to sue you, that I will pay $10,000 of your legal bills if you do decide to keep your video up and they decide to proceed with a lawsuit. So I would like to extend that offer over here, and let's just go over what's going on with this story. So this is a review from Glux Gym. It's a great YouTube channel that goes over some fitness equipment. He reviewed this, and the review is not stellar. He doesn't seem to like this product very much, and I'll just play a couple of clips from the review to get started.
Done. I got this. Woo! We dancing with that cable slack. Now you think that's bad? I spent another half a day tweaking, modifying, and changing things to get it this good. And I have about a 50 email comment chain back and forth with the company trying to figure out what I did wrong. And I didn't do anything wrong. You know what they told me? People have different preferences in how tight the cables are. No, they don't. All we want is a tight cable, so when we pull on it, it's responsive. This is awful.
And he also goes over trying to do a horizontal pull with this thing.
Those big 300-pound stacks, I've got 300 pounds to work with. It's a 2-to-1 ratio. You combine it, ends up being 1-to-1. You get 300 pounds. This is great. And when I'm done with my set, I just break my own feet, because the only way I can get range of motion, this weight is now sitting on my bones, my feet right now, is to telescope this thing out, and the range of motion still sucks. The whole thing's awkward. And that's with me completely ignoring the fact that I've got 2 different cable lengths here, because
So this company has 2 choices. Behind door number 1, they can take this honest feedback, say, thanks for giving your opinion. We're going to make these updates to the product. And who are we kidding? This is 2025. Door number 2, file a bullshit frivolous lawsuit, which appears to be the choice that they've decided to take. I would like to support him in this case. I saw that he has a GoFundMe. My original plan was to cover the $10,000 of legal expenses, the first $10,000 of legal expenses, and it seems like many people in this GoFundMe have already beat me to it. I believe the GoFundMe was at about $3,000 when I started this video. So after $3,000, I will happily throw in $10,000 if you send the bills directly to me. Because if I give to a GoFundMe, the fee is going to be like 5 or 10% or some shit. So after the $3,000 or $4,000 that this GoFundMe is at the time that I'm filming this video, feel free to send the invoices for the law firm to Rossman New Media Inc., 2410 San Antonio Street, Austin, Texas, 78705. Just to introduce myself to Enns and Archer LLP and Roderick J. Enns. Hi, how's it going? I'm Louis Rossman. I have a YouTube channel where I show people back in the day how to fix Apple products. When Apple didn't like that I was publishing their schematics on the channel, their law firm Kilpatrick and Townsend asked me to take them down. Instead of take them down, they have every single one of those videos has remained up today, and a couple of right to repair laws were passed, kind of not the best laws in the world, but were laws that a $3 trillion company did not want passed, and they were. When DCS decided to sue this gentleman for telling the truth in his product review, he won. When Google sent me a letter asking us to cease in publishing a particular piece of software called GrayJ, we essentially gave them the middle finger and continued doing it, and Google has not won. When BWE tried to have my videos going over his business practices taken down, not only did we have his business taken down, but we also did the investigative work to figure out that he was an abusive pedophile, and yeah, that was fun. When the Farm Bureau was saying that farmers did not want to fix their own stuff, we managed to get them on the microphone saying that and managed to use that as leverage to get a right to repair bill passed for farmers. When New York State audited me, after 2 years, they had an error rate of something like 0.01%, and when they referred me to somebody else, that audit had a rate of 0%. And what I'm about to do to you, this is not even my job. I just do this for fun. I have a repair shop to run. I have 3 different nonprofits. This is just by hobby. I am very lucky at this point in my life that, again, while I have a lot of things going on, I do have the ability to make people like you and companies like you my pet project, which I will do if you do not drop the suit immediately against this man. Again, I have gone up against Apple, Google, John Deere, New York State, New York City, and I like many, many more, and I just continue to win. And I'm not going to be humble about it. I don't care. I don't like bullies. I don't like seeing people get trampled by bullies. I will continue to do this over and over again. And if you think that I did not give up for all of them so that I could roll over for some gym company that wants to sue somebody on YouTube, if you want to fuck with this guy's ability to provide honest reviews to his audience, if you want to try and curtail freedom of speech like that, come on, court's in session. So I'm going to read the important parts that I find to this lawsuit. I am then going to read you my response, and just we'll go from there. Rajic J. Ends at Ends and Archer LLP. All right. Okay, that's who we're going up against today. So, Plaintiff Advanced Fitness Concepts, Inc., doing business as Vulcan Strength Training Systems, Vulcan or Plaintiff, by and through undersigned counsel for its complaint against Adrian Gluck, and Glux Gym, collectively, defendants alleges and states as follows. 1. This is an action for injunctive and monetary relief based on the defendant's publication of false, unfair, deceptive, and defamatory statements about Vulcan and its products in violation of federal and state law. Defendants are in the business of posting online video reviews of fitness equipment. They hold themselves out as providing in-depth and honest reviews, but receive compensation from major fitness equipment manufacturers when their reviews generate sales. Defendants persuaded Vulcan, a small veteran-owned company that designs and sells fitness equipment, to send them at no charge Vulcan's Talos all-in-one gym for review. Rather than producing a good faith review, aka, in my opinion, what they mean when they say good faith review is a good review. Defendants published a highly negative video which made intentionally false, misleading, and deceptive statements about the Talos product and made gratuitously disparaging remarks about Vulcan and its products. Defendants produced this incendiary negative review of the small company's product to bolster defendants' reputation for honesty while endangering their revenue streams from large manufacturers. Despite Vulcan's request, defendants have failed to withdraw or correct their defamatory video, resulting in lost sales and profits to Vulcan and irreparable damage to Vulcan's consumer reputation and goodwill. Wonder who's responsible for that. Vulcan therefore brings this action to a halt, defendants' ongoing torturous conduct, and for appropriate monetary relief. So it says who the parties are, boring, jurisdiction, boring, facts come into all claims. Vulcan, founded in 2008, is a 100% veteran-owned company and is registered as a small disadvantaged business with the U.S. Small Business Administration pursuant to 13 CFR 124. And to be clear, I have nothing wrong with Small Business Administration, small disadvantaged businesses or veteran-owned companies. You do you, by all means. But they're setting the stage here for this poor YouTuber made something mad at me. And I don't like that you're using it that way. And I don't think that the average veteran that's in my audience thinks that it's a good idea for a company to sue somebody on YouTube because they said that your product's a little loose and wonky. I don't think that that's the average opinion of the veterans or small disadvantaged business owners in my community, but you let me know what you think. Over the 17 years of its existence, Vulcan has built an excellent reputation among consumers for high-quality products and superior service. For example, on Reviews.io, an independent customer reviews aggregation site, reports that Vulcan's average rating, they've gotten good reviews. So yeah, they've gotten good reviews. They think well of themselves. Next, defendants Gluck and his company, defendants Glux Gym, produce fit reviews of fitness equipment. These reviews typically feature Gluck on camera describing the product. They maintain a website which says that they strive to provide in-depth and honest reviews on well-tested items. In addition to posting reviews on their site, defendants also post reviews on YouTube, Instagram, and other online platforms. Upon information and belief, defendants realize advertising revenue when their reviews are viewed on these platforms. Defendants also maintain a presence on Patreon, an online monetization platform that allows content creators to run a subscription service. Patreon users pay monthly membership fees to view content posted by defendants. Upon information and belief, defendants have agreements with many fitness equipment manufacturers to pay defendants compensation when defendants generate sales of their manufacturer's equipment. Defendants' website lists dozens of manufacturers as affiliates, the largest of which are Robe Fitness and Rep Fitness. Defendants' engagement with Vulcan. Some years ago, defendants applied to Vulcan in North Carolina to become an affiliate and entered into an affiliate agreement with Vulcan that provided, among other terms, that defendants would receive commissions on sales generated by the promotion of Vulcan products, that Vulcan would, in its discretion, provide defendants with Vulcan products to review, and that defendants would avoid slander, misrepresentation, or disparagement of Vulcan products, services, or reputation. In my opinion, what they mean here is you're just not allowed to say anything about our product that we don't like. Defendants were not particularly active as a Vulcan affiliate until July of 2024 when Gluck began communicating with Vulcan's CEO about obtaining Vulcan's Talos all-in-one one gym product review. Glux persisted in requesting a Talos review product, making renewed requests in October 2024, January 2025, and May 2025. In initiating and pursuing these contacts with Vulcan, defendants knew that Vulcan was located in Charlotte, North Carolina, in this judicial district. As a result of these communications, in early June 2025, Vulcan shipped a Talos product from its warehouse in Charlotte, North Carolina, to defendants at no charge for evaluation. As configured by defendants, the product had a retail value in excess of $4,000. After receiving the product, Glux had multiple communications with Vulcan about assembly. Among other things, Glux stated that he was missing some parts. Vulcan advised that new and improved parts were on order and would be forwarded as soon as Vulcan received them. Glux also identified some issues he was having with the Talos product, including concerns about the assembly instructions and the tautness of the cables, but acknowledged that he hadn't been yet able to fully test due to missing parts. In response, Vulcan resent a full copy of the assembly instructions, including 4 detailed schematic pages and a 6-page step-by-step assembly guide, and pointed out the full 3D virtual model showing every detail of the product was available on Vulcan's website. With respect to the tautness of the cables, Vulcan advised that standard cables are intentionally designed with about 1.5 inches of slack. Because customers have different preferences for cable slack, Vulcan ships shorter cables to any consumer that prefers them at no charge. In a follow-up telephone call, Glux said the existing cables were fine and there was no need for Vulcan to send shorter cables. In mid-August, Vulcan learned that the new parts would be delayed longer than expected. Vulcan advised defendants to delay and offered defendants could either continue to wait for the parts, or alternatively, Vulcan would send someone to disassemble and remove the Talos equipment, and parties could try again once later the updated parts had arrived. 27. Glux responded by inviting Vulcan to retrieve the product, saying, "I don't have any way of shipping it back." All right, do that. Defendants' false and disparaging publications. Despite the above agreement to put the project on hold, within 10 days, defendants publicly posted a video online called the 60-second gym tour, in which Glux briefly showed the Talos product on camera and referred to it as a pile of shit. Less than 2 weeks later, defendants posted on the Patreon website a 12-minute video titled "I Just Killed the Vulcan Talos and Maybe Vulcan 2. The Patreon video was only available to members who had subscribed to the defendants' channel, but defendants also posted a free teaser on their Instagram page. Shortly thereafter, defendants posted the same video on their YouTube channel under the title, "This is the worst product I ever reviewed." The YouTuber posting is freely available to the public without restriction. Defendant's video opens with an image of the Talos product in a flaming trash bin. It then shows Glux on camera, who proceeds to make intentionally false, misleading, and disparaging statements about the Talos product and Vulcan as a company, including the following. Glux provides an extended rant about the tension in the product's cables, saying they have too much slack. He dismisses Vulcan's explanation that customers have different cable preference tensions with an expletive, and says this, pointing to cable, is awful. A side note, I would agree. In my opinion, that's not a preference, and I'm pretty sure my personal trainer would agree. That I asked him via Signal, and he did not have many nice things to say about this. Glux claims in the video the grooves of the pulleys are too small for these big, thick cables. The cables are 5 millimeters in diameter, and the pulley grooves are 9 millimeters wide, providing a proper fit. Glux falsely asserts that the user can adjust cable tension from the trolley. Glux states that Vulcan's directions don't say how to install the rear crossmember, causing him to install it upside down. The crossmember only has holes on one side, so it can only logically be installed one way, and the instructions clearly show the proper installation. Glux complains that Vulcan's assembly instructions are incomplete, but comprehensive instructions were emailed to him at the time that the product was shipped. When the instructions were sent to him later, he admitted that he missed them the first time. Just to give you some context here, I would like to show you a piece of the instructions. For anybody who's ever bought a desk on Amazon for $37, gotten like a book of instructions in 89 different parts, and said, "Never mind, I'm just going to send this back and spend $200 in a desk like I should have," this seems similar to me.
Except, step 2, where it's actually like 35 steps in one. And the problem with that is, I'll give you a great example. When we put this bottom cross member in, we put it upside down. Now, how would we know it's upside down? We wouldn't, because there's no indication on the freaking directions. So I put the weight stack on and then realized it's upside down. Got to take it apart and do it all again. The hardware, there's a bunch of different sizes, but they're all within 5 millimeters of each other, and you have no idea what's what. They're caked in grease, so there's just grease and oil on everything here. And I basically resulted in building it by looking at the low-res.
This has happened to me almost every time I have made the mistake of buying a cheap piece of furniture, a desk or a chair or something from Amazon. I realize I could have spent $200 and bought something I could assemble in 5 minutes, or I could spend $20 but buy something that is a 4-hour project. This is not, in my opinion, like, you're going to sue somebody over that. Like, maybe you think that it's not difficult to assemble. Maybe you think the instructions suck. It's a basic complaint. Like, this is just, the fact that somebody would sue over this is asinine to me. Continuing. Glux falsely claims that the lat pull bar doesn't fit properly. It does when the product is assembled per the instructions. Glux asserts that it is not possible to use the band pegs with the product when it is false. Vulcan offers them for an accessory on their website. We're going to cover that shortly. Glux says that the low row function is too low, calling it the world's lowest row. Some competing products have a lower low row, such as one offered by Rep Fitness, which defendants reviewed favorably. Each of the above statements, as well as others throughout defendants' video, were objectively false, and upon information and belief were known by defendants to be false at the time they were made, or alternatively were made by defendants without reasonable basis, and defendants failed to exercise ordinary care to determine whether the statements were false. In addition to the above objectively false statements, Glux also makes many other gratuitously disparaging statements in the video, including Glux calls Vulcan's website the world's worst website with low-res, grainy-ass pictures. Yeah, just my comment over Terry here, like, this is what you're suing somebody over. You hired a lawyer because somebody made fun of what your website looks like. My God, I got a lot of people to sue in my audience in this case. Glux calls the ordering process the worst experience I ever had. Glux says Vulcan's pulleys demonstrate every single thing you could do wrong and they feel like shit. Glux says that of the lat pull down, there's no way they could have made this worse, claiming at one point that there were 47 or so things wrong with it. Glux concludes by saying, if I was one of the people that spent money on this, I'd be pissed. Defendants' motives. Upon information and belief, defendants have active affiliate relationships with Rogue Fitness, Rep Fitness, and other large equipment manufacturers, which generate significant revenue for defendants. These relationships create a dilemma for the defendants because defendants' appeal in the marketplace depends on cultivating a reputation for fearless, hard-hitting reviews, but negative reviews of products from the large manufacturers that impact defendants' revenue. Defendants' solution was to fabricate a negative and incendiary review of the product of a small manufacturer, enabling defendants to portray themselves as crusaders while protecting the competitive interests of the dominant companies in the industry who generate most of the defendants' revenue. I am not a lawyer, but reading this, I don't know what legal definitions are for things. I would imagine that this is what we will call cope. 37. The video about Vulcan's Talus product explicitly pursues the strategy. Glux falsely asserts that he has been the target of legal claims in the past through his reviews, when in fact the legal documents he briefly flashes on screen do not have evidence of claims, demands, or proceedings against him at all. He then proclaims his video won't make me any money, to lose money, a lot of it, so go subscribe. With the subscribe link superimposed on the screen, Glux concludes by claiming that the Talus review will lose me thousands of dollars, which he offers as a badge of integrity. When defendants posted the Talus review on YouTube, Glux pinned a text comment that appears prominently on the page. It reads in part, yes, this video is a bit energized, sure it could have been more professional, but I don't work for these companies, I work for the viewers, and I hope you find this helpful, concise, and fair. Yeah, also subscribe because this has been a stressful endeavor. By the way, this is what we call, my personal trainer would call this processing bullshit. I would call this accepting the premise of assholes. You did a fine review. I watched the entire review. It's totally fine. If somebody doesn't like it, they're fine. What you're doing over here is you are apologizing to people that will already hate you. Do not do that. Stop that shit. Do not explain yourself to people that under any fucking circumstance, no matter what you say or do, will hate you. You don't have to do that. That's not your job. Your job is to create the honest reviews that you make for your audience, not for the, again, you're writing, essentially, in my opinion, you're writing this for the company, for the company's representatives. That's not it. Like this, that's not it. The statement is false and misleading because defendants do in fact work for Rogue Fitness, Rep Fitness, and other large manufacturers, and that defendants derive substantial revenue from favorable reviews of the products and those companies. Defendants nonetheless explicitly hold out their attack on Vulcan and its product as evidence that defendants don't work for these companies writ large, impacted defendants' conduct. Defendants' conduct in misleading Talus review has been widely viewed in the consuming public, including by potential customers in North Carolina and the Judicial District. For example, the video has over 70,000 views on YouTube with over more than 500 YouTube comments. Potential customers have in fact been misled by defendants' false and misleading representations, with a large number of commenters on YouTube complimenting Glux for his supposed honesty and willingness to put integrity over profit. Defendants knew and intended their false and misleading Talus review would cause substantial harm to Vulcan and his reputation and customer goodwill, as evidenced by the title defendants gave the video when it was first posted. I just killed the Vulcan Talus and maybe Vulcan too. Many online commentators on the video expressed negative views about Vulcan and his product based solely on the misrepresentations made by defendants. Just speaking for myself here, a lot of my negative opinion from you does not have anything to do with this video and everything to do with how you responded to it. I may have even had slight doubt about your products, but wanted to do further research upon watching the video. But after seeing that you were suing over what is essentially cope, yeah, it's not the video. It's this. This is what puts the nail in your coffin. Because of the expense of a universal home gym product like Vulcan's Talus all-in-one gym, most consumers will have no opportunity to independently test the product and learn of the falsity of defendants' representations. The allegations of paragraph 1 through 41 above are incorporated by this reference. Defendants' false and misleading video about Vulcan's Talus product constitutes commercial advertising or promotion within the meaning of Section 43A1B of the Lanham Act, 15 U.S. Code Section 1125A1B, and that defendants were acting to advance their commercial relationships with Vulcan's direct competitors. Defendants' video misrepresents the nature, characteristics, and qualities of Vulcan's Talus product. As a direct and proximate result of the defendant's conduct as alleged above, Vulcan has suffered harm and damage, and that has lost and is continuing to lose sales and profits that it otherwise would have earned, and its reputation with customers in the trade has been impaired and damaged. The amount of Vulcan's damages is not reasonably capable of a precise assessment at present, but will be proved with specificity at trial. Defendant's conduct as above is alleged ongoing and will cause continuing, escalating, and irreparable harm to Vulcan's business and reputation unless and until defendants are enjoined by this court. Again, where's the personal responsibility? None. It's the reviewer's fault. It has nothing to do with my actions, how I communicate, or my product. Second claim for relief. Defamation. The allegations of paragraph 1 through 46 above are incorporated by this reference. The falsehoods communicated by defendants in their video tend to impeach Vulcan in his trade or profession, otherwise tend to subject Vulcan to ridicule, contempt, or disgrace. His video, not your behavior. Defendants knowingly published their false and defamatory statements to the general public. Defendants knew that their statements in the video were false and / or failed to exercise ordinary care in order to determine whether they were false. Oh, cool. So you're a mind reader now. As a direct and proximate result of defendants' conduct as alleged above, Vulcan has suffered harm and damage in that it has lost and is continuing to lose sales and profits it otherwise would have earned, and its reputation with consumers has been impaired. They're saying that they don't know the amount of the damages. Vulcan, through its attorney, made written requests to defendants that they withdraw and correct the false representations of defendants' video, but defendants have failed to do so. Defendants' conduct as above alleged. Fuck off. Fuck you, spam call. Fuck you. I'm going after somebody else right now, but I'll go after you later. Third claim for relief, unfair and deceptive trade practices. North Carolina General Statute 75-1.1. The allegations of paragraph 1 through 52 above are incorporated by this reference. Defendant's conduct as above alleged was and is in commerce and affects commerce in the state of North Carolina. Defendant's conduct as above alleged constitutes unfair and deceptive acts and practices and unfair methods of competition in violation of the provisions of North Carolina General Statute section 75-1.1. I didn't go to law school. I'm not going to read that shit. As a direct and proximate result of defendant's conduct as alleged above, Vulcan has suffered harm and damage, and this is just kind of, they're just kind of repeating the same thing over and over there. The precise assessment is present, but it exceeds $75,000. So they're saying that they've received at the very least $75,000 in damage. Defendant's conduct is ongoing. They've willfully engaged. We already read that part. Fourth claim for relief, the allegations of this above. The defendant's false and misleading video about Vulcan's Talent's product constitutes unfair competition in violation of the common law of the state of North Carolina. The defendants falsely disparaged the product, and they're essentially just repeating themselves at this point. Prayer for relief. Wherefore, Vulcan prays that the court enter judgment in its favor and against the defendant as follows: that this court is a preliminary injunction and permanent injunction enjoining the defendants, their employees, representatives, agents, and any persons or entities in active concert or participation with them from further publication or distribution of defendants' false and misleading video. The defendants are ordered to publish a retraction on every platform, so they have to do the "I'm so sorry." Defendants are ordered to serve with the court a written report that they have complied. They are going to try to recover damages. And again, they were saying that they lost at least $75,000. So there's that. They want to recover as many damages as possible. And the people representing them are Roderick J. Enns at Enns and Archer LLP. I guess you should take the video down at that point and just hand over your $75,000. What else are you going to do? Dear Mr. Enns, I'm a YouTuber pretending to represent Adrian Gluck and Glux Gym LLC, collectively defendants in the above captioned matter. I reviewed the complaint and the Talos review video. This letter sets out in a claim-by-claim structure why the pleading is currently framed does not state viable claims under the Lanham Act, North Carolina Defamation Law, or North Carolina General Statute 75-1.1, and why the derivative common law unfair competition claim is not sound. Fundamentally, this complaint attempts to recharacterize a critical product review with subjective assessments and rhetorical hyperbole as commercial advertising and promotion actionable under the Lanham Act, defamation, a treble damages unfair and deceptive trade practice, and common law unfair competition. These theories all depend on the same premise that numerous statements in the video are objectively false, and that defendants fabricated those statements in order to mislead customers and advantage large manufacturers who participate in affiliate relationships. On the face of the complaint and the transcript, many of the challenged statements are classic opinion, evaluative commentary, or rhetorical hyperbole, such as world's worst website, worst experience I've ever had, lazy engineering, pile of shit, and not provably false factual assertions. Where the complaint does allege concrete counterfacts, such as cable and pulley dimensions, cross-member orientation, availability of band pegs, these allegations are conclusory and not supported by exhibits or independent standards. Evidence has not been provided in your complaint. The complaint alleges view counts and generalized reputational harm, but does not identify any specific lost customer, transaction, or quantifiable sales impact attributable to any particular statement in the video. Courts routinely treat strongly worded product reviews and rankings as protected opinion or editorial speech. Courts require significantly more specific allegations to sustain Lanham Act defamation or unfair trade practice claims in this context. Courts reject attempts to claim that harsh reviews are actionable misconduct. In Bose Corporation versus Consumers Union, Bose alleged that Consumer Reports knowingly published a false speaker review that was negative, but the Supreme Court found no actual malice and protected the review. In Seaton versus TripAdvisor, a hotel claimed defamation over being labeled the dirtiest hotel in America, but the court held the ranking was a non-actionable opinion. In Rainsoft versus McFarland, a water treatment company challenged a blogger's statements calling its sales tactics a scam. The court claimed the speech was rhetorical hyperbole rather than commercial advertising. In Golo versus Haya, a diet supplement company alleged false advertising based on negative online reviews, but the court ruled that the critiques were non-commercial commentary and dismissed the claim. The complaint attempts to use trademark defamation and UDTP theories to convert a harsh review into a multi-count business tort case. The governing law and pleadings make success in that approach highly unlikely. The Lanham Act. Let's talk about that. To state a claim under 15 U.S.C. 1125 A1B, a plaintiff must plausibly allege at the very least, 1, a false or misleading statement about a fact of the plaintiff or defendant's goods, services, or commercial activities, made in commercial advertising or promotion that actually deceives or has a tendency to deceive a substantial segment of the audience, that is material to purchasing decisions, that's placed in interstate commerce, and causes injury to the plaintiff within the Lanham Act zone of interest, proximately caused by the challenging statements. Let's go over commercial advertising and promotion. Courts commonly apply the coastal abstract framework to determine whether challenged speech is commercial advertising and promotion, commercial speech by a commercial competitor, or for the purpose of influencing consumers to buy defendant's goods and services, and sufficiently disseminated in the relevant purchasing public. In Coastal Abstract Service for Inc. versus First American Title Insurance Company, the Ninth Circuit set out a widely used test for determining whether a speech qualifies as commercial advertising or promotion under the Lanham Act 43A1B. Under this framework, the plaintiff must show that the challenged statements are commercial speech, such as speech proposing a commercial transaction rather than editorial opinion or commentary, which is what this YouTube video is, are made by the person acting in a commercially motivated manner comparable to a competitor, though after Lexmark, direct competition is not strictly required, are made for the purposes of influencing customers to buy the defendant's goods or services. Is this man selling a fucking home gym? No. Are sufficiently disseminated to relevant purchasing audience. If any element is missing, the speech is not commercial advertising and promotion, and the Lanham Act false advertising claim fails as a matter of law. The complaint's Lanham Act and defamation theories depend heavily on the premise that Gluck intentionally fabricated or exaggerated problems with the Talos in order to promote competitors like Rogue and Rep because of affiliate income. However, Gluck explicitly says that negative reviews get him blacklisted by brands. He says he gets, and I quote, hit with their wrath and loses affiliate relationships. He says harsh reviews lose him money, not earn it. Given that Gluck's affiliate revenue depends on multiple brands, and given that negative reviews diminish affiliate opportunities, the complaint does not plausibly allege that any coherent economic motive for Gluck to sacrifice Vulcan in order to benefit another specific manufacturer. Outside of this letter, just speaking in my experience as a YouTuber, every single time you criticize a company, every single time you have an interview with somebody that is a little bit combative in nature, that there are a bunch of people that will see you as brand unsafe and no longer want to partner with you. This is known throughout YouTube. It's why most of the reviews that you see on this platform are good and shilling for the manufacturer. The complaint alleges that defendants monetize review channel, website, and affiliate relationships convert the Talos video into commercial advertising and promotion because defendants were allegedly acting to advance their commercial relationships with Vulcan's direct competitors. While the pleading describes monetization, ad revenue, and Patreon subscriptions, affiliate relationships with Rogue, Rep, and dozens of other manufacturers, and wide dissemination, 70,000 YouTube views, it does not allege that defendants sell competing home gyms or other fitness equipment, that any competitor paid for or directed this particular Talos video, or that the video invites viewers to purchase a particularly competing product or functions as an advertisement for a competitor's goods. In Rainsoft versus McFarland, the court held that on the specific facts of the case, the blogger was not engaged in commercial advertising because his ad revenue was incidental and his content was plainly editorial. By contrast, Arlix versus NutriSearch allowed a claim where the review publication allegedly had a secret financial arrangement and a formal promotional contract with a single manufacturer, and systematically skewed its rating system to favor that entity. Facts that converted purportedly independent reviews into paid advertising, which is not happening here. Here, the complaint pleads generalized affiliate relationships and economic motives, but does not allege a comparable pay-to-play arrangement for the Talos video. The video itself is presented to viewers as a review, not as a promotion for any specific competitor. Mr. Gluck expressly tells viewers that the video won't make me money, it'll lose me money, a lot of it, and explains that negative reviews cause him to be blacklisted by brands and to lose affiliate revenue. That narrative sits at direct odds with the complainant's assertion that the video is crafted to protect and enhance its commercial relationships with large manufacturers. Alleged misstatements of fact. The complainant identifies several categories of allegedly objectively false statements about Talos: cable slack, pulley dimensions, ability to adjust tension, assembly instructions, and cross-member orientation, lat pull-down fit, and ability to use band pegs and low row height. On their face. 1. Many of the strongest phrases, such as world's worst website, worst experience I ever had, every single thing you could do wrong, lazy engineering, as a functional trainer, this is not good, pile of shit, are classic subjective judgments and rhetorical hyperbole. Courts have repeatedly treated similar language in reviews and rankings as a non-actionable opinion, not false statements of facts. See Seaton versus TripAdvisor, labeling a hotel the dirtiest hotel in America, deemed loose, figurative, or hyperbolic language. And Rainsoft, describing a sales pitch as a scam and a magic show treated as hyperbole in these cases. For the more technical items, pulley groove size, cross-member orientation, and cable slack, the complaint offers bare counter-assertions, such as 5mm cables and 9mm grooves, only one logical way to install, without attaching the drawings, photographs, or standards that would substantiate falsity. Further, the band peg allegation reflects a mismatch. In the video, Mr. Glux says, "I can't use band pegs on this thing," immediately after criticizing the lack of vertical holes and the change hole sizing on the cross members, explaining that this kills your versatility compared to his other racks. The complainant recast this as a categorical claim that band pegs cannot be used, rebutted by the fact that Vulcan sells them as accessories. Even accepting the pleading's characterization, the statement in context reads as a usability judgment about the stock configuration, not a factual assertion that no accessory exists. For instance, this would be like me saying, "I can't listen to jazz on these speakers," and you going, "Well, actually, you can play back John Coltrane just fine." And no, you fuck, I'm not saying that it doesn't play the fucking audio. I'm saying that it plays it and it sounds like shit. Lanham Act claims require provably false statements of fact, not merely harsh opinions about product quality. Courts have been reluctant to reframe subjective product criticism as false advertising, absent clear, specific misstatements and robust evidentiary support. D. Deception, materiality, and injury. The complaint points to 70,000 plus YouTube views and 500 comments and asserts that potential customers have been in fact misled and now hold a negative opinion of Vulcan while praising Mr. Gluck's honesty and integrity over profit. It does not, however, identify any particular customer who elected not to purchase towels because of a specific alleged misstatement, any retailer or distributor who altered its relationship with Vulcan due to the video, or any quantitative sales data or trend analysis linked to the video's publication. And Lexmark International versus Static Control Components Inc. And I can't do Markdown. Fuck, I'm an idiot. 572. The Supreme Court held that a Lanham Act plaintiff must plausibly allege an injury to a commercial interest in sales or business reputation that falls within the statute's zone of interest, and that this injury was proximately caused by the defendant's alleged misrepresentation, typically meaning that consumers withheld trade because of the challenged statements. In the case, the complaint alleges injury in broad, generalized terms, view counts, negative comments, reputational impressions, without identifying specific lost customers, transactions, or purchasing decisions attributable to any particular statement in the review. Defamation. Legal framework. North Carolina defamation requires, in general, a false statement of fact of and concerning the plaintiff published to a third party, resulting in injury into reputation or failing to within a per se category with the requisite level of fault. Where the speech is a consumer product review, it touches on matters of public concern. First Amendment principles require careful separation of fact from opinion, and in many contexts of showing or of knowing or reckless falsity. Bose Corporation versus Consumers Union remains this leading example in the product review setting. Under Gertz versus Robert Welch, punitive or presumed damages may not be awarded for speech on a matter of public concern unless a plaintiff proves actual malice, knowledge of falsity, or reckless disregard for the truth. A corporation may sue for defamation, but must still prove falsity and fault under the applicable First Amendment standards. The false defamatory statements of fact. The complaint incorporates the Lanham Act factual allegations and characterizes the false that's communicated by defendants in their video as impeaching Vulcan in his trade or profession and subjecting it to ridicule, contempt, or disgrace. As noted above, however, a substantial portion of the challenge language is strong opinion, such as the World's Worst website, World's Worst experience, nothing thought out of this thing, and the technically oriented statements are pleaded in the he said, she said fashion, with conclusory counter-assertions but no supporting exhibits. Courts in analogous cases, Seaton, Obsidian, have repeatedly declined to treat sharp-edged commentary and rankings as defamatory when they are understood by readers as opinion, rhetorical flourish, or debate rather than literal assertions of fact. Fault. The complaint alleges that defendants knew their statements were false or fabricated, a negative review to portray themselves as crusaders while protecting their relationships with large manufacturers. Those assertions are made upon information and belief. They are not supported by any alleged admissions by the defendants, internal communications indicating an intent to lie, or specific facts showing that defendants believe their statements were false. In the video itself, Mr. Gluck explains that harsh reviews lead to brands blacklisting him, terminating affiliate relationships, and reducing his income. He states bluntly that this video won't make me money. It'll lose me money, a lot of it, and that he's losing thousands of dollars. That on-camera narrative of perceived financial self-harm is at odds with the complaint's interference that the review was engineered to protect affiliate revenue. In the aforementioned Bose case, the Supreme Court found insufficient evidence of actual malice when a speaker review was mistakenly described as wandering around the room. This demonstrates that criticism in product reviews is strongly protected absent a clear showing of knowing falsity or reckless disregard. The pleading here presents conclusory assertions of knowledge and motive without the kind of particularized factual support that courts ordinarily look for. In Bose versus Consumer Union, Consumer Reports published a review of Bose's 901 speaker. The reviewer described the perceived audio by saying that the sound from the speakers tended to wander around the room. Bose argued that this description was factually false and that the reviewer knew it was false because during internal discussions, he had said that sound wandered along the wall, not about the room. Fucking weasels, if there's any other reason to not buy Bose. Gee. Bose claimed this discrepancy was evidence of actual malice, that the reviewer intentionally exaggerated the effect to make the product look bad. The Supreme Court rejected Bose's argument. The court held that the reviewer's description was not a knowingly false statement. The phrase reflected a subjective perception of the acoustic effect, not a verifiable factual claim, and the difference between along the wall and about the room was a good faith interpretive choice, not evidence of lying. Similarly, saying a child who is hyper is bouncing off the walls versus jumping all over the place is not a lie in the former when the clear-cut intention in each would be to get across that the child is acting hyperactively. Injury. Plaintiff alleges lost sales, profits, and reputational harm, but identifies no specific customers, lost contract, or sales data. It relies on view counts and generalized commentary. Where the underlying statements are predominantly evaluative and opinion-based, the showing of falsity and fault is limited. Such broad allegations of harm are unlikely to bridge the gap required for a successful defamation claim, even under a per se theory. 4. Unfair and deceptive trade practices. A private claim under Section 75-1.1 requires an unfair deceptive act of practice, unfair method of competition, in or affecting commerce, proximately causing actual injury to the plaintiff. Unfair practices are those that offend established public policy or are immoral, unethical, oppressive, unscrupulous, or substantially injurious. Deceptive practices are those with the capacity or tendency to deceive. The statute is aimed at business practices in the marketplace, not every controversy involving business entities. Unfair, deceptive act, or practice. The UDTP claim incorporates all prior factual allegations and simply labels the defendant's conduct, such as publishing the Talos Review and the same alleged misstatements, as unfair and deceptive acts and practices, unfair methods, as discussed above. The alleged deception is the same set of disputed statements analyzed under the Lanham and defamation sections. Much of the content is plainly evaluative or hyperbolic, and the complaint does not allege the defendants themselves sold Talos units or competing equipment, misrepresented prices or terms, or engaged in classic unfair trade practices such as bait and switch, hidden fees, or deceptive contracting. North Carolina courts have emphasized that 75-1-1 does not convert every commercial dispute or tort into an unfair trade practice claim. See Dalton versus Camp, holding that an internal employment business dispute was not within 75-1.1's intended scope, and commentary warning against bolt-on UDTP claims without aggravating marketplace misconduct. The UDTP claim here adds no new conduct beyond the speech already at issue. It simply relabels a single critical review as an unfair method of competition, a characterization that is difficult to reconcile with how Section 75-1.1 has traditionally been applied. In or affecting commerce, the complaint alleges that the defendant's conduct was in commerce and affects commerce, pointing to their monetized channel, website, and affiliate relationships. Those allegations plausibly involve defendants in a commercial ecosystem, but the specific conduct at issue is editorial commentary, not a sale or solicitation. Section 75-1.1 commerce requirement is broad but not limitless. Courts have drawn lines where applying the statute would transform it into an all-purpose vehicle for business-adjacent grievances. Proximate cause of actual injury. As with the Lanham and defamation claims, the UDTP count alleges lost sales, lost profit, and reputational harm in conclusory terms without identifying specific lost customers or transactions or offering any sales data tied to the video. In misrepresentation UDTP cases, North Carolina courts generally require a showing that alleged deceptive act proximately caused the injury, often through proof of reliance or a similar causal nexus. The complaint does not describe any consumer who relied on a specific alleged misstatement, such as band bags or pulley grooves, in deciding not to purchase the Talos. Instead, it infers injury from view counts and general commentary, a notably high-level approach given the statute's remedial weight. Common law unfair competition. The fourth claim for relief asserts common law unfair competition, again by incorporating all prior allegations and asserting that defendants falsely disparaged Vulcan and its product in order to advance defendants' commercial relationships with Vulcan's direct competitors. Under North Carolina law, the common law unfair competition traditionally requires conduct such as passing off, misuse of trade names, or marketplace confusion between competing businesses. As pled, this claim is entirely derivative of the Lanham Act, defamation, and UDTP theories. It identifies no additional conduct behind Talos video and the same alleged false statements. It rests in the same speculative motive theory regarding affiliate relationships and alleges the same generalized damages. To the extent that the underlying theories fail for the reasons discussed, opinion versus fact, lack of commercial advertising and promotion, and absence of specific injury and causation, the common law unfair competition claim rises and falls with them. Weakness of this entire fucking case. Viewed claim by claim and as a whole, the complaint falls on its face. Factual foundation. Many key statements are opinion or hyperbole, typical of reviews. Technical disputes are pled as bare contradictions without supporting evidentiary detail. Commercial speech status. The Lanham Act and UDTP claims attempt to recast Mr. Gluck's editorial review content as commercial advertising and promotion and unfair methods of competition without alleging the kind of concrete promotional arrangements seen in cases like Arix or the kinds of sales-oriented practices as Section 75-1.1 is intended to regulate. Fault and intent. Assertions that defendant fabricated a negative review and knew their statements were false are made on information and belief without corroborating facts and are difficult to reconcile with the transcript's explicit acknowledgement that the video will cost defendants money and affiliate relationships. Injury and causation. The complaint alleges lost sales and reputational harm, but identifies no specific lost customers or orders and offers no data tying any downturn in performance to the video. For both Lanham Act and UDTP claims, Lexmark and North Carolina Authority require a proximate link between the alleged misstatements and concrete injury. Derivative nature of state law claims. Defamation, UDTP, and common law unfair competition counts all reuse the same factual allegations and alleged motives to the extent that the underlying review is editorial opinion rather than actual misrepresentation. Derivative claims stand on the same footing. In conclusion, This letter is intended to set out, in a structured way, the principal legal and factual issues we see in the complaint as presently drafted. The federal state claims all turn on the same core set of challenge statements and motives. Under the governing authorities, those statements largely fall on the opinion/criticism side of the line. In the commercial advertising or promotion, and unfair deceptive trade practice characterizations are tenuous, and the allegations of causation and injury are notably sparse. We remain prepared to address these issues in the appropriate procedural posture. Should be sitting up properly, actually. In the meantime, we trust this analysis clarifies why, as pleaded, the claims face significant obstacles under an established law and the actual contents of the Talos Review. That defense is worth what Gluck paid for it. However, if you would like something better, I will commit to what I said in my original video. Let's make sure that we send a message. And the message is going to be like this. When somebody uses their First Amendment rights on YouTube to review a product and provide their opinion on that product, we are not going to stand by and allow that person to get bullied by the company. Thank you very much to Mr. Gluck for following in what I was talking about in that Cameo Research video, where I said, fuck taking your original video down and cowering until later. He never did. He kept his video up. He never wavered. And I want to see the community rally around that and support it as much as possible so that is the default in YouTube culture, rather than this bullshit where somebody deletes their review or hides it for 3 to 6 months and puts it back up later. Like, no, we're not doing that. We're going to make sure these companies are held accountable and responsible. And if you wind up getting negative reviews as a result of this, whether it's End & Archer LLP, the law firm, or whether it's Vulcan Fitness Products, that has nothing to do with us because we didn't start this fight. You did. Do not start a bar fight and then call the cops. Do not play the victim when you are the one who is screwing with people and you are the one that is trying to bring people real financial harm for simply discussing your products using protected First Amendment speech in the United States of America. If you don't like what I have to say about it, I fucking dare you to sue me. We can have some real fun with that one. That's it for today. And as always, I hope you learned something. See you in the next video. Bye now.